and welcome to the Heir Waves podcast, a show about all things wills, estates and succession law in Australia. Your hosts, Kate Brewer, succession law barrister extraordinaire, and Michele Davis, lawyer, educator and succession nerd, have a mutual love and deep interest in all things succession law. In this podcast, Kate and Michele share stories, thoughts and considerations of wills, estates, trusts and succession case law from around Australia. Join us on the Heir Waves for all things succession law, and be sure to subscribe and follow the podcast for all the latest episodes. Please know that the information provided in this podcast is for general information and educational purposes only and should not be construed as legal advice under any circumstances. Please get specific legal advice for your particular circumstances. Any views or opinions expressed by our hosts or any of our guests are the personal views of that person and are not representative of their employers or any organisations or bodies of which they are affiliated. Hello, everyone, and welcome to the Heir Waves podcast. I'm Michele Davis, and I'm joined today by the lovely Kate Brewer. How are we today, Kate?
Hi, Shell. I'm really good, thanks. Hi, everybody. Thanks for tuning in.
Yes, as always, it's a pleasure to have you all here listening along to some nerd talk by us. We're going to talk about something super duper practical today. We thought we'd talk about a little bit about family law proceedings in the context of estates. And I'm going to let Kate take the lead on this one because it is something that she deals with all the time. Straight over to you, Kate. Tell us all about it.
Thanks, Michele. So this topic arose out of a paper that I presented recently for the Family Law Practitioners Association conference at the Gold Coast about a month ago. I think it was early June 2023. And the paper was on the crossover between family law and succession law. And it covered a lot of areas such as statutory wills, mutual wills, severance of joint tenancies, many other things. But what I did at the beginning of the paper was I discussed some of the very fundamental principles of succession law and how they might relate to family law, and in particular, family law litigation. So I covered things such as explaining what a grant of probate is, what's the difference between a common form and a solemn form grant of probate, what is letters of administration compared to probate, what happens when a party to family law proceedings dies or loses capacity, or indeed what happens when somebody who has rights in relation to family law proceedings but hasn't commenced them yet dies or loses capacity. And the feedback that after that talk was that people really liked that 101 introductory stuff. So Shell and I thought it might make a good podcast topic for today. So first up, apologies to any experienced lawyers listening, especially succession lawyers. This will all seem a little bit trite and you might want to switch off. It's up to you. But of course, the principles that I'm going to discuss here are relevant to any litigation, not just family law, although obviously there are different rules in different courts, but the principles will pretty much still be the same, or at least similar. So, grants. A grant of probate is simply the official recognition by the Supreme Court that a particular will is the last will of a deceased person. A common form grant of probate is what 99% of grants are. It's done on the papers. That means you just file documents in the court. You don't appear in the court. And it's issued by the probate registrar of the Supreme Court. So you simply advertise, which is notice to the world at large that you intend to apply for probate of a particular will. There's certain wording that you have to comply with, and there's a certain place you need to do the advertising for. You then give official notice, written notice to the Public Trustee of Queensland by simply sending them a copy of the ad that you run. And so that's so that they can check their database and advise you or let you know if they hold a later will for the person that you're applying for probate for. And if nobody objects, if the PT doesn't object, as long as you've got all the correct paperwork lodged, then the court will usually issue a grant of probate on the papers, and that's called a solemn form grant. Now, what that is, pre-electronic probate or pre-electronic grants, it was the original will because you lodged the original will in the probate registrar, and there was a piece of paper put on the front of attached to the front of the original will, which is actually called the grant, and that has the court seal on it, and the seal would then be put on each page of the will. That's a common form grant of probate, and a solemn form grant of probate is where the court, that is a Supreme Court judge, has actually made a ruling that a will is valid. Or sometimes you can have a solemn form grant or a declaration against, in solemn form, against the validity of a will. But when we're talking about the grant having been made, the Supreme Court judge has found after a trial that that will is valid. So usually someone firstly challenges the validity of the will by filing a probate caveat in the Supreme Court. There's a trial, usually takes about a year to 2 years to get to trial, and then the court makes a decision as to whether or not the will is valid. After that hearing, those findings are made, the grant of probate that issues after that is called the solemn form grant of probate. Now, that again is issued by the registry, the Supreme Court probate registrar, because all the judge does is makes a declaration for or against, in solemn form, the validity of the will, and then directs that the probate registrar issue a grant subject to the formal requirements of the registrar, issue a grant in solemn form. Now, again, you can get to the end of a trial, and if you haven't right at the beginning of the day done your advertising and you notice to the public trustee, that will be one of the requirements that the probate registrar will make you do before you can physically get a grant in your hands. So what about letters? So that's what a solemn form grant is. What about letters of administration? Well, there's two types of letters of administration. Probate of a will can only be granted to an executor who is named in the will, including a substituted executor. So if the named executor, or both, if there's a substituted executor, both named executors can't act for whatever reason, now that might be because they're dead, or they're incapacitated, or they just don't want to, or they can't be found for whatever reason, then someone else applies, where there is a will, someone else applies for a grant of letters of administration with the will annexed. Now, that grant is called a grant of letters of administration, and the person who obtains the grant is called an administrator as opposed to an executor. So an executor is only ever and can only ever be the person who is named as the executor in the will. Now, an administrator is basically the equivalent of an executor as far as what their powers are and what they can do. They're all, for all intents and purposes, the same or very, very similar. There are some slight differences, but for today's purpose, the main one that matters is this. An executor's power derives from the will. So it operates as soon as the deceased person dies. An administrator's power only derives from the grant of probate. So when the court makes the grant, that's when they get their powers. There is a doctrine of relation back, so that once the grant's made, they are deemed to have had those powers since the date of death. But between death and the grant being made, they have no power to do anything at all and no authority to do anything at all. So an executor can act as such from the very minute of death. And Section 45 of the Queensland Succession Act says that a deceased person's property vests in the executor on death. A lot of other states are going to have similar rules, although I think some states actually provide that the property doesn't vest in an executor until a grant of probate is made. So you would need to check what jurisdiction you're in. An administrator has no authority at all to do anything unless and until the court makes a grant. So anything that they do pre-grant, they have no authority for and risk getting into some fairly serious trouble if a grant isn't ultimately made to them. The other type of letters of administration is called letters of administration on intestacy, and that's when someone dies without a will. Again, the grant is called a grant of letters of administration, and the person who gets the grant is called the administrator. Now, to administer a deceased estate in Queensland anyway, you don't always need a grant, but there are a number of reasons why it's always prudent in every case for an executor to obtain a grant. The important one for today's purposes is if the executor if the executor is engaging in litigation. Courts generally won't recognise an executor's right to litigate on behalf of a deceased estate unless the executor obtains a grant of probate. Of course, if there's no will and therefore no executor, then a grant of letters of administration is essential before an administrator can take any steps in relation to any litigation, because, as we just discussed, no one has any power to commence or continue or defend litigation on behalf of an estate without a grant. So no will, or there is a will but the executor's either unwilling or unable to act, then a grant is an absolute necessity before you can do anything with litigation. With probate, so if there is a will and an executor willing to act, you really need to get the grant of probate to confirm your authority to act as an executor, and the court that the litigation is involved in generally won't recognise that authority without a grant, so it's usually a necessity. So that brings me to the next topic. What happens when a party to an existing family law dispute dies? Now, again, we can broaden this to any dispute, but I'm going to be talking about family law disputes. If there are no proceedings on foot, then in family law, it's too late. You can't file in the family court after a party has died, nor can you bring a constructive trust claim in the state courts, because it's the exclusive jurisdiction of the family court for matrimonial causes. So the parties are left with whatever their rights are under the will or intestacy laws, if there is no will, and under family provision laws. And every state, of course, differs as to who can bring family provision applications, but generally speaking, a spouse can bring a family provision application in any jurisdiction, because it's spouses and children, usually plus dependents, who are eligible to bring family provision cases. So generally a spouse will always be eligible. Having said that, if it's a divorced spouse, they may not be eligible. If it's a de facto spouse and there has been a separation and an ending of the relationship, they may also not be eligible. But there's some exceptions to both of those rules. Again, you need some specialist advice there. This is, of course, different to other litigation, potentially, so such as a commercial litigation in a state Supreme Court. That kind of litigation, then an executor can commence a proceeding on behalf of an estate, even after the death of the person. However, this does depend on the nature of the cause of action we're talking about and whether it's a statutory right that dies with the person. Again, some complicated legal issues here, so you'd need to get specific advice on your type of litigation. But just remembering that today I'm talking specifically about family law proceedings. If there are family court proceedings already on foot but not concluded and a party to them dies, then the executor or the administrator, if there's no will, steps in and acts for all intents and purposes as that deceased person. They are what's known as the legal personal representative of that deceased person. So it's then no different to litigation in any other court. The court would need to make orders substituting the legal personal representative as the party in the place of the deceased person, but that would be usually fairly procedural in most cases, I would imagine. And most of the time, it will be non-controversial. Having said that, there's always going to be a delay, because you can't just continue with the litigation. Even if there's an executor, that would be the easiest scenario. There's an executor, there's a will that is not in dispute, and nobody has an issue at all about the validity of that will. The executor can simply step in and take over those proceedings on behalf of the deceased person, but they will need to get a grant of probate, and that will take usually a minimum of about 6 to 8 weeks. Again, that depends upon where you are, which state, and you can sometimes get grants made on a more urgent basis if it is urgent. But in the ordinary course, that's going to take 6 to 8 weeks to get that grant through the Supreme Court before you can then go back to the family court and say, here's my piece of paper that allows me to step into the shoes of the deceased person. Sometimes in litigation, that's not going to matter so much, that kind of delay, but depending upon what the issues are, it might be super important, and there might be an urgent grant application that needs to be made. Most of the time, though, that will be non-controversial. Where the difficulty arises is where there is a dispute about the validity of the will. So in that case, who has the authority to act? There's a will. We've got family court proceedings on foot here today. There's a will from 2022, December, and then there's another will from 2015. There are different executors named in each will. The person who is the beneficiary in the 2015 will says, I dispute the validity of that 2022 will. Who's got authority? Executor's authority derives from the date of death. Property vests in the executor upon the date of death, in Queensland at least. So does that mean that the executor under the 2022 will has authority? Well, no, not necessarily. So where there is a dispute about the validity of the will, then it can't be determined who's got the authority to act in those family court proceedings until the Supreme Court has determined which is the valid will. So here's where family lawyers will generally need to engage the services of a succession lawyer. The Supreme Court can and do on a regular basis appoint an interim administrator to conduct the family court proceedings on behalf of the estate, if those proceedings need to be determined first. What about if the proceedings are over? You have orders, or you have consent orders that have been made, but they're wholly or partly unexecuted. Well, in that case, the legal personal representative, so either the executor or the administrator, simply steps into the shoes of the deceased person. Again, administrator obviously has to get a grant first. The executor, very prudent to get a grant, although potentially not essential. If you don't have to go back to the court for any reason, then the orders can simply be carried into effect with the LPR simply acting in place of the deceased person for the orders to be perfected. But if you have to go back to court, then you go back to the above. You have the substitution of the legal personal representative as the party to the litigation. And when I say if you have to go back to court, I'm talking about you've got those orders in place and then a party dies, and then there's a dispute about, for example, whether or not those orders should be now carried into effect given that someone's died. One party might be saying, well, yes, everybody's bound by them. The other party might be saying, well, no, given that there's one of the parties has now died, it's not appropriate for those orders. And that obviously is a matter that needs to go back to the family court to be determined. So when I say if you have to go back to court, then you go back up to the above. You need to have a substitution of the legal personal representative as the party to the litigation. And so that would be either the executor or an administrator, and you'd need to get a grant before anybody could do that, before the family court would recognise the authority of that LPR to continue or conduct this litigation on behalf of the deceased person. So that's the basics in a very simplified nutshell about the effect of death on family law matters. Another important matter that happens fairly regularly is, what if a party to family court proceedings loses capacity? Well, in this situation, if there is an attorney, so if there is an enduring power of attorney document that has been signed pre-losing capacity, then it's the party's attorney who has the authority to conduct the litigation on behalf of that person without capacity. So an attorney is a person appointed, an attorney by an enduring power of attorney. If it's a general power of attorney, then general powers of attorney, their powers come to an end upon somebody losing capacity. So it must be an enduring power of attorney because that endures after the loss of capacity. An attorney is also called a person's legal personal representative, or LPR, and so that person simply conducts that litigation on their behalf. What if there is no attorney? that if there is no attorney, then you have to go to, in Queensland, QCAT. In the other states, you have VCAT in Victoria, NCAT in New South Wales, and most other states have the equivalent of a tribunal that deals with the appointments of administrators for persons without capacity. So in Queensland, you have to go to QCAT and get an administrator appointed. Now, it's a little bit confusing that these people are called administrators because it's the same word or the same descriptor that's used for the person who takes out a grant of letters of administration. We generally refer to them as a financial administrator appointed by QCAT. So the difference is that it's appointed while the person is alive for someone who has no capacity, as opposed to an administrator appointed by the Supreme Court in a situation where somebody has died is also called an administrator. But where people have, where we have adults without capacity, then in Queensland, QCAT has exclusive jurisdiction to appoint administrators. There is one small exception that isn't relevant to today's discussion, but generally the general rule is that it's exclusive jurisdiction of QCAT. That administrator then becomes the person's LPR, legal personal representative, and can conduct negotiations on the principal's behalf. If it's prior to proceedings having been instituted, then the LPR conducts the negotiations and has the power to resolve them, to enter into binding agreements. If court proceedings are required, consent orders, then you would need a family court order appointing the attorney, who is the LPR, as the litigation guardian for the person without capacity. The court won't make orders just based on somebody being an attorney. They would need to be appointed as a litigation guardian. If an attorney wants to or needs to commence family law proceedings on behalf of their principal, then again, they need a court order appointing them as a litigation guardian. But if they are commenced without such an order, then those proceedings aren't a nullity. They're simply irregular, and the court can make the order retrospectively, in effect, fixing it up. And there is a recent decision of Justice Jarrett in the family court of Holden and Holden that confirms that that's the law in the family court, and that's a 2023 decision, I think, in about May this year. If it's during the proceedings that the person who's a party to the proceedings loses capacity, then again, the attorney or the administrators will need to apply to the court, that's the family court, to be appointed the litigation guardian of the person. Now, there's a difference here between state courts and the family court. In the state courts, well, at least in Queensland, a litigation guardian simply files a consent to act as a litigation guardian, and that makes the appointment effective unless it's then challenged by someone else. In the family court, the court needs to make the order appointing the litigation guardian, so it's a separate application to the court for that purpose. If it's after orders are made that the person who's a party to the proceedings loses capacity, then the attorney or the administrator simply steps into the party's shoes in enforcing the order. No court order is needed unless for some reason, again, you need to go back to court to get further orders. Then you'd need to get an order appointing the person as the litigation guardian before they can do anything at all. And that, in a nutshell, is the summary of law as it relates to the crossover between succession law and family law, particularly family court proceedings.
That is such a good topic, isn't it, Kate? Because the amount of people that in my practice as a planner, I find people actually do question what happens, how does it work, and especially I think for second marriages, third marriages, that kind of thing. And if someone's just gotten a diagnosis and they're concerned about what that means if they were in planning to perhaps separate and things like that. So with that in mind, what as a litigator, seeing how this works procedurally and everything else, what would be some really handy advice to have if you had a client in front of you as a planner saying, I was planning to separate, I've just had this diagnosis, what do I What do I need to think about?
So of course, it emphasises which all planners, estate planners know this anyway, but it emphasises the importance of having a valid, enduring power of attorney in place and having the person who's your attorney be the appropriate attorney for you. So if you've got a client who comes in and has recently separated and their attorney is their separated spouse, well, that's the last person, obviously, who would want to have as their attorney. So do they have a substituted attorney? Obviously, you should be revoking that power of attorney sooner rather than later. And also just the importance, I think, too, in the will planning stage of having appropriate substituted executors and potentially more than one. It just depends on the situation, but sometimes it's just not appropriate to have I'd still see wills where there's no substituted executor, and it really would be a cautionary tale to consider who's going to be your executor. If that person's not alive or can't act, who's going to be your substituted executor, and would they be appropriate in a contested proceeding with your former spouse? For example, if your best friend and your spouse hate each other, then it may not be appropriate once you've separated to appoint that best friend as your enduring power of attorney, because they might not be the best person to conduct litigation against your former spouse, because when there are personal and emotional feelings involved in that kind of thing, it can just make litigation carry on longer and be much more expensive for everybody involved. Somebody who's more capable of remaining neutral and remaining unemotionally involved and detached,
as objective as possible.
Those sort of situations is obviously going to be better than somebody who, hates the other person's guts. Yeah. So careful thought as to who the appropriate attorneys and executors and substituted executors should be.
Yeah, and I think that's probably worth mentioning at this stage, that even though you always want someone who's appropriate, who's going to fight for what you would fight for in the circumstances where you could yourself. But when Caite talks about, someone who's going to act appropriately and everything else, it's more to make sure that it doesn't get unnecessarily dragged out, overly complicated, and, being a legal matter, excessively expensive. And unnecessarily so, because the conduct of parties can drive those costs really significantly. So the last thing you want to deal with is, ridiculous legal costs because people are just incredibly passionate, but perhaps just, making it a little bit more hard, more difficult than it has to be. Yeah. So I thought that's worthwhile just mentioning, especially for those that might be listening who've never gone through a litigious matter. It can be easily thrown out in terms of those costs. And I think that it's just goes back to, again, me being the planner that I am, I think it goes back to the importance of holistic estate planning. It's not just about the will. Having a will is excellent, yes, but it is clearly not just about that. You need to look at the bigger picture, and especially if those concerns are sort of there in your circumstances. Are you separating? Are you not? Are you having some struggles and you haven't decided whether you're going to separate or not? All those sorts of things definitely come into play. But for some people, the procedures and things like that of what happens in a family law dispute, if you were to pass away or lose capacity, are going to be front of mind for clients in those circumstances.
Absolutely.
So, I think it's a really, really great topic, and it'd be good to actually have a bit more of a topic about another podcast perhaps in the future. Maybe we can talk about a couple of cases that this sort of does come up, and let people see how it really gets dealt with in the nitty-gritty of things. But I think that's a fantastic starting point, getting through those basics and helping people understand how it all actually works. So thank you for that, Caite. You really had the reins on this one.
No problems at all.
Yeah,
thanks.
Really good. So there was a couple of notes that I'll from Caite's talk just about the case that she mentioned. I'll put that in the show notes. But as always, I'd really like to welcome people to reach out if they have any particular queries about this topic that you'd like us to talk about in more detail. And we do hope this is actually quite a practical approach to our podcast today, with dealing with those, procedural, nitty-gritty kind of things that sometimes clients really do want that insight when they're giving you those instructions in a planning context, or if you've got a litigious matter that's getting a little bit and you need some sort of insight. And I'm sure Kate would be available to have a chat with you about going to court if you need to go down that road. So
I do often have just consults with family lawyers, including their family law barrister, because something might come up in this context and they just need a bit of guidance and pointing in the right direction. And it's pretty rare that I do more than just one consultation with them, because that's usually enough for them to sort of work out what they need to do, and then they continue on. I don't act in family court matters, but just getting that sort of advice from what happens on the estate litigation side of things and helping them to conduct the litigation accordingly. So.
Yeah, and I think it's really helpful for us practitioners on all edges of estate work to be able to advise clients of what it looks like, because these things it's strategic in terms of a lot of things you've got to handle. You've got a lot of balls up in the air when that kind of thing actually does come to fruition, when someone does pass away or lose capacity. So I think this being very practical will help people just get a bit of an insight into what happens. But at the same time, it's no substitute. This podcast says no substitute for getting that detailed insight about your matter. So by all means, reach out to Kate if you've got litigious matters coming your way that have this particular nuance about them. Definitely get that insight so that you can really get some, give the client some understanding of what it all looks like, because they're at the same time, they're already grieving, whether it's grieving the death of loved one or the lack of capacity of someone. That will just be able to give them that better understanding of what's to come as best one can anyway. Well, look, I think we might perhaps leave it there, Kate, and definitely put out a call out to all of you listening. If there is something you'd like us to delve into a little bit more about this, or any other topic for that matter, we always welcome you to reach out to us. You can reach us at hello@theairwaves.com, and please, by all means, let us know what you'd like to hear from us next on the podcast. But I really want to thank very, very kindly to Kate today for taking the reins on this one and letting us know these really valuable and very practical insights about family law disputes in the estate world and what it looks like. So thank you, Kate.
No problems at all. And thank you, everybody, for listening.
Yes, thank you all. And we will see you next time on the airwaves. Have a great day.
Bye.
Bye.